Good afternoon. My name is Nancy Mabin. I'm a member of the Professional Development Team at HRPA. Welcome to today's live webinar, A Human Rights Approach, OHRC's Policy Statement on the COVID-19 Pandemic. To provide additional time for individuals to log in, I'd like to briefly alert you to our next webcast. On Thursday, July the 9th, HRPA will deliver the next webcast, which is Workforce Contingency Planning for COVID-19, how to prepare for the changing needs of your company as it navigates this new era. The COVID-19 situation is driving companies to scale back their teams instead of growing them, and trying to predict HR needs in this rapidly changing time is a little like gazing into a crystal ball. This is creating stress on HR teams as both their workload increases and they are expected to have the right tools and strategies to respond. By attending this webcast, you will better understand the cost of long-term non-retention of laid-off or on-leave employees for your organization, the impact of the post-layoff communication process on company branding, in other words, social media, the importance of developing a process for COVID-19 health check-ins, the changing nature of work during COVID-19, and the best strategies for HR practices moving forward. Now for a few quick housekeeping remarks. We ask that you mute your video and microphone. If at any time you experience technical difficulties, indicate the issue to us via the chat box at the bottom of your screen. Questions can be submitted via the Q&A box, and we will not be using the raise hand option for today's session. Finally, your feedback is very important to us. Take a few minutes to complete the survey that will be sent in the next few days. The recertification or CPD code for this live online program will be provided at the end of the survey. Now I'm very pleased to welcome today's facilitator, Jeff Poirier. Jeff Poirier is a senior policy analyst at the Ontario Human Rights Commission. His functions include legislative monitoring and preparing public submissions and policy statements on various issues, including the COVID-19 health pandemic and human rights, gender identity, competing rights, disability accommodation, and implications of the cannabis laws. He has also managed communications in public education and worked in other areas, including international human rights and Francophone affairs. Also joining us today as a co-moderator is Bryony Halpin, who recently joined the Ontario Human Rights Commission as a senior policy analyst in the fall of 2019. At the OHRC, she works on issues pertaining on education, COVID-19, and poverty. And now I'm going to take it over to Jeff. Jeff, just let me pull up the presentation. There we go. Over to you, Jeff.
Great. Thank you, Nancy. Thanks, everybody. The Human Rights Commission, we appreciate the opportunity today to speak to HRPA members. So yeah, I'm going to do my presentation here, and hopefully we'll have quite a bit of time for questions and answers. So this presentation is about COVID-19, employment, and the Human Rights Code. So just on the overview slide here, just give me an idea what I'm going to cover in the next 20 minutes or so. I'm sure many of you are, aware of the Human Rights Code in the system, but I'll just do a quick, reminder overview of the code in the system, and I'll get into talking about balancing rights, and then more specifically COVID-19 and the Human Rights Code, the duty to accommodate. What our policies, say about health and safety requirements, and then get a bit more specific on medical testing, medical documentation, absenteeism policies, discipline termination, and then over to your questions. And just a reminder, at the end, I'll have a list of resources. So I'm just covering some things in my opening presentation here, but there's a lot of issues that we do have covered on our website as well, a number of questions and answers that have come our way regarding COVID-19 and the Human Rights Code, and maybe you'll have some of those same questions for me today. So next slide. So Ontario's human rights systems, there's three agencies or three parts of the system for Ontario. There's Human Rights Tribunal. So that's a place where people who have claims of discrimination can bring their claim to the Human Rights Tribunal. And the tribunal has, their mandate is it's kind of like a court, but they always try to mediate and settle matters that come to them, or they can hold a hearing. There's the Human Rights Legal Support Center, and they can support claimants with their claims, either provide them with initial advice on the situation they might be experiencing, or if the matter does end up in the Human Rights Tribunal, they could choose to assist somebody there as well. And then there is my agency, the Ontario Human Rights Commission. So our mandate is different. It's quite broad, and we do things in the public interest. So that's the side of our mandate. So we don't deal with an individual's matter, although we could get involved in a matter at the Human Rights Tribunal. But we would need to see a public interest reason to do so. So maybe it's because the case is raising novel issues, or it might have some kind of systemic impact across a sector, or particular types of institutions that are a public interest matter that were a focus area of the Commission's work. Otherwise, our mandate and our functions are quite broad. We do research, policy development, that's the area I'm in, and my colleague Bryony, also public education like today, but we do public education events like today, but we also do consultation on various issues, and the Commission has inquiry functions and powers and intervention functions and powers. So currently we're doing inquiries into reading disability issues in the education system. We're doing an inquiry into racial profiling with Toronto Police Service, and we're involved in cases at the tribunal. So it just gives you like a whole range of things that we might get involved in. But definitely in this spring, with the emergency declared in March, a lot of our time and attention has turned to COVID-19 related issues and implications for the Human Rights Code. So I was going to try and get into more of that now. So next slide, Ontario Human Rights Code. So again, the basics. The code prohibits discriminatory treatment, and that includes harassment. It includes the duty to accommodate people. The code covers 17 grounds across 5 social areas. In employment, it's not all 17, but it's most of them. And I listed a few there: disability, family status, age, race, ethnic origin, place of origin. These are some of the grounds that have been coming up in COVID-19 related issues this past spring. And the 5 areas that the code cover is employment, which is what we're here for today, but also vocational associations, that would be unions or professional associations, those kinds of bodies related to employment. And of course, we cover services, housing, and contracts, and pretty much employers are typically service providers. So there's that angle of the Human Rights Code as well. And the code covers all terms and conditions of work, from the hiring process to, a retention training, performance review, all the way up to termination. And just to be clear, so we're the Ontario Human Rights Commission, Ontario Code. There is the Canadian Human Rights Act. It covers, federal government ministries, agencies, and anything regulated by the federal government, like interprovincial transportation, telecommunications, that kind of thing. So everything else would be a provincial or territorial jurisdiction. And in case for Ontario, it's our Human Rights Code, which has primacy over other Ontario law. So next slide, balancing rights. So like our code, above our code, actually, we have the Charter of Rights and Freedoms, the Canadian Charter of Rights and Freedoms. And it also it also sets out people's civil and political rights and equality rights. That part of the Charter is similar to our code, the right to equality and freedom from discrimination based on the grounds set out there. But the Charter also has provision for justifiable limits, in society. It's a high bar to meet, but limits on rights or balancing of rights can happen. There's a provision for that in the Charter, and the same with Ontario's Human Rights Code. So again, it's non-discrimination based equality legislation. But it also recognizes that requirements can be legitimate, it can be bona fide and reasonable, particularly health and safety ones. And sometimes requirements have negative effects on people, and then there's a duty to accommodate. So I'll get into more into that as I go through the rest of the slides. But with respect to COVID-19 and requirements, health and safety requirements related to COVID-19, what this means here under the code is that these things need to be legitimate, bona fide, reasonable, evidence-based, effective, appropriate in the situations, right? And then they can stand up in the sort of balancing of rights provisions that the human rights law has. So next slide, disability, the code ground of disability covers COVID-19. So the definition of disability in the Human Rights Code is quite broad. It sets out all kinds of conditions, but it's not exhaustive. And courts have recognized that it's not a finite definition. Its understanding and meaning can evolve over time, and it has. So it covers a broad range of medical conditions, and these include, conditions that people actually have or perceive to have, and some of them may carry, stigma like addiction and so on. So this spring, the Commission took a policy position. It said that the Human Rights Code covers COVID-19, i.e., that COVID-19 is a type of medical condition that the code covers, and it's engaged when there's differential treatment, negative treatment related to COVID-19. So negative treatment of employees who have had or are perceived to have COVID-19 is discriminatory unless legitimate reasons related to public health and safety are there in the balance. So next slide. COVID-19, it can be covered by the ground of disability, but situations related to COVID-19 can engage or impact other code grounds. And some of them here are family status, age, race, color, place of origin, ethnic origin, and so on. One of our early statements in January, when in Canada, Canada started to see its first cases of COVID-19, we were receiving media reports and other types of reports about the treatment of racialized individuals, people from China or other Asian countries, and they were facing harassment and stigma in public or in services. So, unrelated to the condition of having COVID-19, but stereotypes about people's beliefs and who's associated with, the coronavirus, so on. So that engaged those kinds of grounds under the code. And other grounds can be engaged too, and we'll talk about those as I go through my presentation. So next slide, duty to accommodate. So again, these are probably human rights principles that you're already familiar with. So employers have a duty to accommodate employees in relation to COVID-19 and a code ground. So example, employee who has COVID-19 or requires time off, right? So they have a disability condition, COVID-19, they may require time off to recover. So that would be their accommodation request. And employers, need to they have the duty to fulfill accommodation requests unless it would amount to undue hardship. And the code sets out a standard for that: cost, health, and safety. So we'll talk a bit more about that as we go through the slides. Next slide, duty to accommodate continued. So just a reminder that the duty is procedural and substantive. It's process and outcome. And more often than not, cases that end up at the Human Rights Tribunal, sort of that place of last resort when things can't get resolved within an organization, they tend to be more, when they involve the duty to accommodate, they tend to be more about the process than the actual outcome. There can be a myriad of ways and situations how somebody may or may not be able to be accommodated depending on their situation, their condition, the particular workplace they're in, their job duties, and so on. So there's, but often it's about the process. Something went wrong in the process, and it's a shared responsibility, all parties, the employer, the employee, and so on, if there's a union involved, right? So part of that process is taking accommodation requests in good faith, and sort of going on from there, and being flexible, exploring options, and that's both sides, that's the employer and employees. And in the case of COVID-19, somebody who needs accommodation related to that, well, some of these things we're already doing anyway, like everybody's doing these things now, physical distancing measures, in the workplace, modified facilities and duties, alternatives, staggered work hours, work from home where flexible, where feasible, leaves of absence. So some of these types of things are already being employed for all of us. I work at home now because the nature of my job allows me to do that. But people with disabilities, they may need something as well, but it might be different than whatever everybody else needs. And so their individual's needs need to be examined. Again, part of the duty to accommodate is to look at the individual in front of you and see what would work for them. Even though you may have these procedures in place that work for everybody, that's great, but not everybody will be able to necessarily follow the same requirements. And so, for example, being sensitive to the vulnerabilities of an employee who themselves or maybe a family member has, compromised immune system, like perhaps they're going through cancer treatment, that kind of thing. Next slide. So a bit more about health and safety requirements. So our position here in terms of what we've said in our recent policy statements on our website, so health and safety requirements related to COVID-19 generally do not cause concern under the code, because again, the code allows for legitimate health and safety requirements. And certainly everyone recognizes we're in the middle of the pandemic, and health and safety things are really important now to protect people. So, that's sort of the starting position, but the requirements may have a negative effect based on the code ground on individuals. Somebody might not be able to comply, and what we're saying here, this, must not lead to some kind of automatic negative consequence. You're not complying with our COVID-19 requirements at work, you're fired, that kind of thing. Like this automatic, approach to the negative outcomes is what we caution against. Really, it's, okay, maybe the person cannot comply because of the nature of their disability. They're asthmatic or something, and they can't wear the mask. And so it's exploring what could be done for the individual, and just ensuring there's no automatic negative consequences to not being able to fulfill health and safety requirements. The requirements themselves must be bona fide and reasonable. Legitimate, meaning they were set up to accomplish an appropriate purpose, and they're effective at doing that, and that there's no alternative that would avoid the negative effect, right? So meaning we've designed our health and safety requirement in the best way we can. That means it minimizes negative effect on people as much as it can. It still accomplishes the legitimate goal of protecting people. So that's important to think about. Health and safety requirements. Sometimes they're coming from above, right? The province has declared a state of emergency. It has set out lots of guidelines. Some of them are hard requirements. Some of them are guidelines. So in an example there's no provincial requirement that we must wear masks. But then when you start breaking it down into, looking at particular sectors, workplaces that deal with food production, the Occupational Health and Safety Act comes into play, then these things start to play out differently, and maybe a mask is going to be a requirement somewhere for a particular type of occupation. Even in services, there's no provincial decree about wearing a mask on transit, although there's guidelines for it. But certainly some transit authorities like TTC have taken the position, no, we in our context, in the situation of Toronto, as opposed to small town Ontario, we need to mandate masks. So, each situation can drive different kinds or different degrees of health and safety requirements that will be legitimate in one situation and not in the other. And employers need to look at the requirements that they're following, and whether they're decrees or guidance from somewhere else, ministry or government, or because in their own workplace they've devised their own that makes sense for the employer's environment. Again, it's sort of back to this formula, making sure they're effective, they're legitimate, they have least impact on people protected by code grounds, and then even so, last bullet here, there's a duty to accommodate the individual needs of an individual. So even if you can defend your workplace health and safety requirements as legitimate, and it's going to be a rule or requirement that applies to most people in the workplace, you need to keep the open mind of, okay, we may still have to do something different for an individual who comes forward and makes a code ground claim to us that, the general requirement, that might be fine for everybody else, but I need something a bit different. And then you're back to that process, that duty to accommodate process, to explore and see what can be done for the individual. Next slide. So medical testing, things can continue to get sort of more demanding or complicated or specific to particular workplace environments where, maybe medical testing might be required or expected or so on. Thinking like temperature taking, for example, employers who now take the temperature of their employees because they work on a food production line. So as they come into the plant, they're scanned with a device. So it's not very intrusive, little things point at your head, and you're quickly read your temperature and away you go. To other kinds of testing, right? But anyway, regardless of the type of testing, and the commission has sort of taken a policy position here that a code ground of disability is engaged because you're now sort of acquiring medical information about somebody, and that could have a negative impact on somebody who does have a medical condition considered to be a disability under the code, right? So again, driven by the situation, but the code starts to be engaged here when medical testing starts to happen, any form of medical testing. So in the past, the commission has developed policies and has spoken out particularly about drug and alcohol testing, right, as a form of medical testing. So in this context of COVID-19, we're applying a similar analysis, right? Okay, it's another form of medical testing. What are the human rights principles involved? How should we look at this? So again, we're saying that the code ground of disability is engaged, and it may be permissible for determining employee fitness to perform job duties, in circumstances like COVID-19. So you connect all the dots, and it might make sense to do that particular form of testing. But again, you need to be able to show and ensure yourselves and demonstrate that's effective and necessary. So effective that it works, that the screening allows you to keep your workplace safe, and that it's necessary in the situation. So, in the midst of a pandemic, certain things may be necessary, but as the government moves us from phase 1 or stage 1, phase 2, phase 3, and right now they're anticipating, releasing the state of emergency in mid-July. They may or may not do that, but they're starting to see, more positive direction here. Then, at some point, the testing may not be necessary, right? And then maybe it'll be necessary again if things change. So testing requirements should be consistent with medical and public health advice. So, and there's a lot of good resources out there now that, general advice to the public, but also the Ministry of Labor has developed, continues to develop specific guidelines for various industries, construction industry, and so on. And so really relying on those resources is important because somebody's done the research to say, oh, okay, these kinds of requirements, this kind of approach is legitimate, makes sense in this context that we're in right now. But we also recognize, employers, above and beyond the guidance they're getting from above, that they may need to do more things specific to their environment. So then we're back to the code analysis that requirements, particularly health and safety requirements, can be reasonable, but they just sort of need to follow, what makes them reasonable. And if you read any of our policies on we set out legal tests and requirements, guidance around what are bona fide and reasonable requirements, and how to look at those. And we're also saying in our recent policy statements, comments, that a qualified person should be conducting medical tests, right? Because again, it's that level of information is important. So the next slide, medical test results. So again, like any other medical information we get from our employees or applicants, having to do with, okay, we need you to do this medical test to demonstrate your fitness to perform your job duties. It's the results of the test. What do we do with those? The results must not lead again to this automatic negative consequence, right? So a concern may be triggered, but you sort of can't have these absolute rules about that relate, that bring in discipline and termination and so on. Because a code ground may be involved, a disability may be involved, a medical condition may be involved, and the duty to accommodate is that process again. So in the case of COVID-19, it could be an employee exhibiting certain symptoms. It doesn't mean they do or do not have COVID-19, but that's usually how like the preliminary screening starts, right? Or a test shows employee may have had, or has not yet been exposed to COVID-19. And concerns are starting to be raised about that area of things where, as we go through the ups and downs of the pandemic, we could find ourselves in situations where organizations, service providers, or employers are looking, once science has a better sense of, oh, okay, you've had, you showed you've had the antibodies, you're immune or not. I don't think we're there yet. And Human Rights Commission is definitely not the expert on these things, so we're not going to pronounce one way or the other. But in a world where we do arrive at a point where science and medical community can determine, if people are immune or not, and what would that mean for, the employment world around sort of testing and demonstrating you're able to perform your job, that kind of thing. That can get into tricky territory. So we haven't said too much about that yet, but there are sort of human rights principles for analyzing these kinds of situations. And of course, that duty to accommodate is always short of undue hardship. So that undue hardship standard has been tested through case law, and it's a high onus for employers to try and demonstrate undue hardship. So a little bit more on medical tests. Continue, next slide. So information, as I said, may negatively affect employees who already have maybe they have COVID-19, but they may have another pre-existing disability, and it could be a negative effect on them because of that. And the employer should only receive the information necessary, right, for testing in order to assess these three things: employees' fitness to perform the job that they do, that may limit their ability to perform the job, and any accommodation, sort of help deal with the restrictions they're experiencing and getting them back to doing their job. And sometimes the accommodation is time out, right? There's not always a way to accommodate somebody so they can continue to do their job. It may be time away from their job. And excluding the other information, identifying, that may identify another disability. So it's really just getting the information you need, but only the information you need. And so this relates to, the medical test results, relates to the next slide around medical documentation. And the Commission's, range of the Commission's policy on ableism, the duty to accommodate, some of our other policies, go into this aspect of what do we do with the medical documentation. So human rights law recognizes that some medical information may be necessary to verify and support a disability-related accommodation. So again, employees can be expected to cooperate to provide information, sufficient information to verify their need. And requests, at the same time, requests should be least intrusive of privacy. And what we're saying here during the pandemic is to be flexible, to not overburden, right, the healthcare system with the request for medical notes and so on, or unnecessary visits to medical offices, because all of this can increase people's exposure and so on. So to be flexible in times of emergency, in times of pandemic. And the information you do get, like anything, not just COVID-19 medical related, but any medical information you get from employee you need to make sure it's secure and kept safe. You're maximizing confidentiality. So that means, limiting access to the information to just the people who need to know. So, taking people's temperature, as they come into work, you don't want to start circulating rumors. Oh, so-and-so who had this high temperature today and whatever, like really it's private information, right? I mean, you may need to deal with the situation, but at the same time, you have to be careful not to, like what you do with the information you have. So the next slide is, this is just to ensure that the next two slides, like ensuring that the policies that you do have in place are not used in a way of not having a negative effect on people. So yeah, because of COVID-19, people may be away more for various reasons. They might have been medically quarantined. Government travel restrictions might mean they've come back from somewhere and they have to stay home. Their kids may be home because of school disclosure, or they have somebody living with them with a high risk, for immune or compromise, somebody with immune deficiency disorder. So there could be, various reasons why, somebody has gone past that absenteeism threshold that may be in some organizational policies, and not to treat those as punitive, right? Because now they're related to COVID-19. Now they're related to either disability or family status or some other code ground. So there are legitimate reasons to be absent, and shouldn't have sort of like a negative punitive outcome for people. Same with the discipline and termination. It cannot discipline or terminate an employee, because they were diagnosed with COVID-19 or they're perceived to have it, or they exhibit symptoms, and they're unable to come to work because, again, these kinds of reasons, public health official advice, around either being quarantined or what people should be doing. People over 70, for example, should be staying home and not going out too much or at all, that kind of thing. So all that said, in the same timeline that we started to develop our policy statement related to COVID-19, you can see that on our website. There's also a set of questions and answers to get into more specifics around various issues, and you might ask me about some of those things later. But at the same time, the government actually, it's coincided nicely, the government made amendments to the Employment Standards Act. That's my next slide, with respect to infectious disease and emergencies, right? So from my understanding, the amendments, they kick in when we're in this state of infectious disease emergency like we are now. So these, when they're in effect, these provisions of the Employment Standards Act allow for job protected leave without pay. So no one's expecting employees to be paid, but the nature of the organization, the employer, you could have benefit. Already you have sort of benefit policies or whatever for paid leave, so then they would apply too, but the law is not requiring paid leave. But what it does say, a job protected leave without pay, under medical if the employee is under medical investigation, supervision or treatment, is in isolation or quarantine, again because of other requirements outside of the employer's organization. Or the provision in the ESA also says employees who need to take care of children because of school closures or daycare closures, and so on, or people affected by the travel restrictions. And the amendments say that employers, you cannot require an employee to provide a medical note if they need COVID-19 related leave. So again, sort of not to have this effect of people circulating in the healthcare system when they don't really need to, and to avoid transmission of infection. And the requirements are retroactive to January 25th. So they're invoked now, but they, again, they may be uninvoked, as things progress in the province and the state of emergency is lifted. But in any case, whether they're invoked or not, Human Rights Code is still there. And when a ground like disability or family status is invoked, then the duty to accommodate is still there as well. So this next slide, other legal obligations. So again, things you probably know much better than I do. Employment Standards Act also, addresses termination, severance, notice of turn, all those kinds of things that may happen in a situation of COVID-19 pandemic, where particular kinds of employers may just go out of business, right? Unfortunately. And then, of course, the Occupational Health and Safety Act. There's provisions in the Act, and there's guidelines prepared by the ministry specific to COVID-19, more general about employees' right to stop work when it's unsafe. Again, that's not the Human Rights Code, that's not our jurisdiction, so you'd have to read more about that from the ministry's website, but it factors into all of this. Yeah, so that's the end of the formal side of my presentation. So I think we're doing okay for time here. And I'd be happy to take anybody's questions. And I'll take a sip of water.
Okay, so thank you, Jeff. So our first question, does an employer have to accommodate an employee if they need to stay home with their children or an ill family member?
Okay, so yeah, like employers, they must, okay, so that's triggering grounded family status, right? So employers must accommodate employees who, an employee who has like caregiving responsibilities, right? Unless it would cause the company undue hardship. So, a very small company with 5 employees and all employees are like, okay, I need to be home with my kids. I'm not sure what would happen in that situation because ultimately the organization employer needs to function, right? So they might claim undue hardship when, the nature of the accommodation request is ultimately just putting them out of business or shutting them down. So again, the code has this balancing provision short of undue hardship. But like we're temporarily in the midst of, of a pandemic, right? And so people's accommodation requests, particularly now, can be short-lived, and it's hard. This may only be temporary, and they were able to work ultimately. So that has to be factored in. So yeah, it could involve the family status, the grounded family status under the code. It might be another family member who's ill. Either the employee or their other family members in self-isolation, again, according to government requirements, or the child's schools closed. These are all reasons why somebody might ask for this kind of accommodation. But there's the potential accommodations, like exactly what accommodations they get. So maybe they need to be home, but is work from home feasible? So for my job, it is. So I can't say to my employer, well, I don't want to do any work at all because I can work from home and I'm able to. So again, that the accommodation solution is something that all parties explore and need to come up with something that's, if it can be, the accommodation will allow the employee to continue to work, then that can be what's expected. But it could be just different, right? Working alternative hours, taking a temporary leave, and then still coming back later. Or what other options that employer might come up with, that makes sense in their environment. And again, the Employment Standards Act, the emergency provisions now protect that kind of leave. Yeah.
Okay,
So the short answer is yes.
Thank you. Next question. The example you provided, for example, employee not wearing a mask due to asthma. Can you provide an example of alternative or accommodation to this? For example, for a receptionist.
Okay, so yeah, a receptionist would be dealing with, I guess, members of the public, employees coming into the front door. So that's kind of like a high volume exposure kind of situation. And maybe the employee, again, I'm sort of making up a scenario in my head, right? Maybe the employee, because they're asthmatic, have an asthma or another respiratory disability, that they're just not going to be able to wear a mask all day and not go into some kind of asthmatic attack or something. So is that kind of scenario? Oh, what else is possible? Would a plastic face shield where you can breathe much more easily, would that work? Can a plastic barrier be put up in front of the reception desk? Can two-way, speaker communication be used instead of having people to be right there in person in front of the receptionist? So again, there's probably various options that can be considered, and well, what does the facility and the actual physical environment look like? Because the one option may make sense in one employer and may not make sense in the physical environment of another employer. I'd be wondering, okay, is it the reception's duty to do that job all day? Is that like 100% of the person's job? Did they do other things? Could they job share tasks? Okay, so during this time, relatively short-lived, a few months, maybe another employee can take over more of the reception duties, and the employee who normally does that could do other types of duties, filing or whatever. So to the extent that an employer has flexibility around job sharing duties, changing the physical environment, they need to exercise that flexibility. And certainly, unless, again, they can claim undue hardship somehow, but it's a long shot. Usually you put lines together, there's a way, there's a solution.
Jeff, next question. Are
Sure.
there any grounds for which employees may refuse medical testing, for example, their health, etc.? And if so, can they be accommodated?
So the medical testing, so this is tricky. So now we're talking about employees, not applicants. The employer, again, if I think of our drug and alcohol testing policy and the legal principles in there, the employer has to show that due to the nature of the job, the medical testing is a legitimate requirement. And otherwise, so you have to start with that. And it's legitimate because it's trying to achieve something, right? So if, let's say it's a food production line, the employer has to guarantee that food does not become contaminated by, an employee. And nobody's going to dispute that objective. Like, you got to do whatever you're going to do so that doesn't happen. But the way you've chosen to do that medical test, is that going to guarantee that outcome? And particularly in the situation of COVID-19, as the medical profession is it's an evolving situation where we're learning more about what can be tested, what can be determined. But we all know this, there's self-screening, there's all the symptoms and the signs, the temperature, feeling unwell, sore throat, whatever the symptoms are, and you screen employees for those things. But if you keep going along continuum and you want to argue, well, I need a negative COVID-19 test, this is definitely getting into trickier territory. And I think employers would need to sort of up the ante on the kind of job they're talking about. Certainly an administrative person working in an office or, well, maybe they don't even need to be in the office to do their job anymore. But certainly there won't be an argument to have them tested, but another more, vulnerable health and safety sort of situation. But then you get to somebody refuses, well, you can't make somebody do a medical test, but there could be repercussions. Okay, well, then you can't do that job. But it's for the employer. The employer has the onus, right, to demonstrate that the requirement that they've put on the table, medical testing in some kind of form, is legitimate, and the employee can't do their job without it. But maybe the employee can't do it, but the employee, for the code to kick in, the employee needs to claim something related to the code, right? Code grounded disability or something. And it could mean that, okay, they can't do that job, but there could be alternative work that the employer has for that employee. Again, it's a temporary form of accommodation, right? I can't do this job, but maybe you could do this other one that doesn't require medical testing. But the flexibility for the employer to do that, offer alternative work, will depend on a number of factors. Our policy on ableism and accommodating disability on our website, it sets out a number of factors for alternative work. So again, it's that idea that something's happened, you can't do a test, you can't meet a test, or a test result shows a problem, and the employer is arguing, okay, for that you can't do this particular job. But our policy position and the case law in other similar kinds of situations is saying, no immediate negative, consequence. Go through a process, see how this can be mitigated, see if there's a solution that allows us to meet our health and safety objective, but doesn't have this negative effect or deals with the person, their interests and concerns. But if it's not code related, if people just don't want to do something for another reason and a code ground is not factored into it, but then it's, the Human Rights Code would be silent on that kind of situation.
Thank you. Next question. People are afraid to take the TTC or commute to work. Does this trigger accommodation under the OHRC?
So again, I won't know exactly how everything will play out in a COVID-19 context. Let's say somebody brought a claim to the Human Rights Tribunal. I can say though, from other kinds of situations in the past where employees have requested accommodation related to travel to work, as part of their accommodation. So an example would be, because of the nature of my disability, I can't travel that far to the workplace. I need to access one of the employer's, facilities closer to home, or I need, I can't, like whatever, I have a disability and I can't use public transit or I can't drive a car. So I need the employer to accommodate my travel to work in some particular kind of way. So those kinds of claims in the past, to the best of my knowledge, have not worked under the Human Rights Code, like in the sense that the employer's duty to the employee isn't about getting them to work and home, unless the employee in the nature of their job is travel, right? So once they start work, now they're somebody who works, who travels as part of they're inside their work hours, and now they travel as the duty of their job, one of the duties of their job. So then the employer would need to accommodate traveling while on duty. But from our policies and the previous case law, I don't recall that, successful cases that had to do with getting people to work as an accommodation or getting them home. So, that may be how the COVID-19 situation is analyzed. But I don't have like a line in the commission policy to point you to COVID-19 and duty to accommodate travel, but that's how we speak about other similar situations.
Okay, next question. Can an employer require an employee to work during the COVID-19 pandemic?
Yeah, like if the employee is able to do their job, the expectation is that they do it, right? And the employee needs to bring forward a code ground related reason why they can't. Oh, because of the job I do, I can't do that now because of my disability. I have a compromised immune system. I'm just way too high risk if I continue to do my job the way I was doing it before the pandemic. And now they're requesting some kind of accommodation, either a different way to do their job or time out from their job temporarily, and that becomes the accommodation request. And then the onus is on the employer to show why they could or cannot do that. They'd have to demonstrate undue hardship. Sorry, can you just repeat the question again? Because I think there's another part I need to cover.
Oh, sure. Can an employer require an employee to work during the COVID-19 pandemic?
Right. So again, the employee needs to claim a code ground to be able to say, well, I can't, work during the pandemic, and the employer would have to show undue hardship or otherwise somehow accommodate that employee. Yeah.
Okay, next question. Can an employee refuse to work if they believe the workplace is not safe?
Yeah, so that would typically be a question under the Occupational Health and Safety Act, right? So there's provisions, the government, the legislature has thought of that okay, when the workplace is unsafe, we put provision in law where employees can refuse to work. But that's because there's something about the nature of the work itself that's causing the risk. And then the employer, the employee has a right to stop the work, and then there's a process of investigation that's all related to that. So that's not the Human Rights Code. But if the code kicks in or can overlap when the employee, so that situation wouldn't require the employee to invoke a code ground. I can't work because of my disability. I can't work because of my family status. All they need under the Occupational Health and Safety Act is to say, well, I can't work because my workplace is unsafe, right? And again, whether they can or not and what happens is not the Human Rights Code jurisdiction. But if the employee says instead or also says, no, there's something, maybe my colleague can work in this environment, but I can't, and it's because of a code ground reason, now you have to follow the Human Rights Code, the duty to accommodate, and the process and the law expected under that piece of legislation.
Okay, next question, Jeff. Can an employer redeploy an employee to do work not related to their current job because of COVID-19?
Right, so this gets tricky because, particularly if it's a unionized work environment with, collective agreements that say what employees' rights are with respect to their job and what employers can do around redeployment and so on. Now, I mean, the Human Rights Code, again, is the higher law in Ontario over all the other law. But the government has thought about this to some degree because part of the emergency management, temporary provisions that have been put in place under the legislative change and the regulatory change, temporary or not, is that for some occupations like healthcare workers and healthcare institutions, despite what a collective agreement might say, the government has said, well, no, the employer does have a right to redeploy the employee, in these particular situations. But again, the Human Rights Code, it's neither here nor there, right, for us, unless so you have that kind of situation where the government has already said the employer has the right to redeploy. And then you would have other situations that don't fall under the current temporary provisions government has set up, but the employer might say, well, I need to redeploy you because what we used to do, what we used to sell, nobody's buying that. Nobody wants that service right now. But you know what? We've come up with a new thing and we need you to do this new thing because we're producing hand sanitizer now as opposed to something else. And so we need you to do something different that you weren't doing before. And so you get into sort of, labor law and all of that. Again, not the Human Rights Code, concern, but if the employee says, for whatever reason, you know what, I can't do the redeploy job you want me to do. I could do my original job without an accommodation, but the new job you want me to do, now a code ground has kicked in because of my disability, for example. I can't do that job. As is at least. So then you're back to that duty to accommodate procedural analysis, right? Okay, well, so the employer might say, okay, well, we need, there's no use doing your old job for the moment because we just don't need that job done, right? But if this new job, could you do it if we accommodated you? So if we did this, would that allow you to do it and deal with the limitations you have related to your disability? Or it could be family status, right? So you go through the same process to see if the employee can be accommodated so they can do the redeploy job. But ultimately, they might not be able to do that job either. So they could have done the original job, but because of a disability or family status or whatever, they're not able to do the redeploy job that the employer wants them to do. The employer could still say, okay, they could look around for other productive work to have the employee do. And then the employee might be expected to do that if it does not interfere with limitations they have related to a code ground. And then, so if they can't do any of the above, they can't do the original job, they can't do a redeploy job, or the employer just can't find any productive work for them to do within their limitations. Well, then their accommodation request, as long as it's connected to a code ground like disability or family status, it becomes time, I need leave, right? Because I normally could do my job, but right now I can't for a code-related reason, disability, whatever, during a pandemic, and I need leave from work. So that may be with or without pay. And that's a whole other question, sort of, what can you expect around benefits? So that may be the case. And even the Employment Standards Act, the emergency provisions recognizes that. It says, if they can't do their job for COVID-19 related reasons, leave without pay is protected. So yeah, so in a short way to answer it, the employer can expect people to do redeployed work, but it's pending labor law, it's pending collective agreements. But it also can be limited by the Human Rights Code if people make a code ground claim why they can't do the redeployed work.
Thank you. Next question. Can an employer send an employee home and ask them not to work because of COVID-19?
Yeah, so if the employer, as I was saying in the other situation, if the employer, they just don't have the work anymore, it's completely dried up because of COVID-19, then yeah, it's not, the employee's laid off because the employer no longer has productive work for them. And that, that doesn't invoke the Human Rights Code per se. But again, the employer needs to be careful about, what amounts to termination and so on. And I believe there's been some some amendments to what is termination, the factors that trigger termination and the obligations an employer has when terminating an employee. I believe the emergency provisions that have changed in the Employment Standards Act. So during an emergency, those things around termination have changed. But those are not about the Human Rights Code. So employers just need to, so if they're in that situation where, oh, wow, we've got to lay off, 2/3 of our employees because the demand on our business has dropped by 2/3 and we just don't need all of you right now during a pandemic and they need to lay off people. Okay, well, that's not a code issue unless the employer starts to do something like, you know what, we're going to lay off all the older workers, the ones closer to retirement. We're going to lay off people who, are on leave, although they might have been slated to come back sooner. Like if laying off starts to happen based on a code ground, any code ground, right? From disability to age to race or whatever, now they, caution, right? Human Rights Code kicks in again. But as long as it's done in some other fair way that doesn't invoke Human Rights Code ground, then that's that.
Okay. Next question. Can an employer refuse to hire someone or not continue their employment if they have, had, not yet had, or are immune to COVID-19?
Okay, so again, this is sort of reminiscent of the medical testing policy we have around drug and alcohol testing, right? So the commission has not yet taken a position. So if you look at our COVID-19 statements that we've made in the last couple of months, we haven't gone into this one particularly, and there's not a specific Q&A on this, but it's a form of medical testing, right? So if you're saying to an applicant, let's say, that sort of refused to hire part of the question, I'm not going to hire you unless you go through a medical test, and in this case, let's say they expect a negative COVID-19 test. Again, I can't say exactly how this would turn out if the whole matter went to Human Rights Tribunal. But if I analogize over to, sorry, I have trouble with that word. If I draw an analogy over to drug and alcohol testing pre-employment, our policy on that and related case law. So the commission discourages pre-employment medical testing of any kind, like although we haven't taken a specific position on COVID-19, but in the past on other things, we've discouraged that. But the case law says, okay, well, if a conditional offer of employment has happened, and it's the kind of job, safety sensitive. So in my analogy over to drug and alcohol testing, you're a truck driver, you operate dangerous, heavy machinery. So our pre-employment medical test is you're going to go for a drug test, before starting work. The case law, human rights case law says, well, only do that after a medical, conditional offer of employment, a conditional offer of employment, and only if it is that kind of job, that safety sensitive job, right? Where that's considered a legitimate requirement on the job to be drug free or to be alcohol free, impairment free. Even so, we as a commission don't even recommend that, but the case law has ruled it out after conditional offer. So if that's how that would turn out if a case went to the tribunal, certainly the tribunal or court is going to look at the previous case law around other types of medical testing because they don't have any examples of COVID-19 testing yet. And that same kind of analysis might apply. So the thinking there is, okay, well, the person is otherwise qualified, right? They went through all the hoops. They demonstrated, reference checks, tests, whatever it was to get to that conditional offer. And all that's left now is, okay, you need to pass a medical test. At least that allows to show the person was qualified. And if they're not hired, we'll know why they're not hired. It's not because they're not qualified. They made it through and they got an offer. They weren't hired because of the medical test. And then only that part will be examined to see if it was legitimate at all in the situation. So caution there. And the same, you know, at the other end of it, termination, right? Okay, well, we'll keep you employed, but, or put another way, we won't terminate you unless you go through a medical test to show that you are, you know, and so again, in the case of the analogy, if it was drug and alcohol testing, and you work in a safety sensitive job, an employer can demonstrate that it's legitimate to do some kind of, regular drug and alcohol testing in order to make sure you're working safely, then, you know, it's possible with, if all done properly, and we have a whole policy about how to do that properly, then it is possible to have that kind of medical testing, and there can be repercussions. But again, our basic line is that there should be no automatic negative consequences. If somebody tests positive in any kind of medical test that's legitimate related to their job, that procedural duty to accommodate kicks in. This is not automatic termination or whatever, right? That becomes only a last resort, right? After all efforts are tried or whatever. And it's not even punitive in that sense. It's just the person is unable to fulfill the essential duties of their job. So you'd have to have that kind of situation to be able to say to the employee, you've tested positive in a COVID-19 test and you can't do your job anymore. So I can't give you sort of this one-liner, that is or is not discrimination, because it's going to be driven by the context of the employer, the situation, the job, what we know the best, medical information about how effective a COVID-19 test is. And okay, so it shows you had COVID-19 in the last 14 days, but in 14 more days, you won't have it anymore if you do another test. So why should that lead to termination, right? So, there's so many factors involved here on how that, whether that could be done in a legitimate way that does not interfere with people's rights under the Human Rights Code. It's possible. But we're still in the middle of a pandemic, and these kinds of things haven't been worked out. So my final word on these kinds of things would be caution, right? So employers who go down these roads, they risk facing a claim of discrimination before the Human Rights Tribunal. I don't know how it would turn out, but they risk those kinds of things.
Okay, thank you, Jeff. So we are at the end of our time today, and I'm just going to start my video. Before we actually conclude, I'd just like to thank Jeff Poirier for delivering today's webcast, and Bryony Halpin for helping us with that as well. Finally, thank you to everyone who's attending today. A reminder, your feedback is important to us. For individuals who are attending this live broadcast, we ask that you please take a few minutes to complete the survey that will be sent in the next few days. The recertification or CPD code for this live broadcast will be in the last question of that survey. Also, this webinar has been recorded. A link to the recording will be sent to all registered participants. So thank you, Jeff, so much, everyone. Take care.
You're welcome.
Bye-bye.
Thank you.